Have you become close to a partner's child only to lose contact with the child when your relationship ended? Hi, I'm Simon Dippenaar and I'm a family lawyer. The nature of families is constantly evolving and the law is working hard to keep up. If someone who is not biologically related develops a deep bond with a child, do they have a legal right to continue that relationship, even after they've broken up with the child's biological parents? Now, a recent court case provides some answers and sheds light on the rights of non-biological guardians. The case concerns a man and a woman who had been in a relationship. For convenience, I'm going to call them John and Mary, obviously not their real names. When they met, Mary was pregnant. The child, I'll call him David, was born in December 2017. John quickly took on a loving parental role in David's life, even though he wasn't the biological father. John and Mary lived together as a family with David and John's older son from a previous relationship. For several years, John played an active role in raising David. However, when the relationship between John and Mary ended, Mary denied John any contact with David. John was devastated and sought legal advice as he felt the relationship he had built with David gave him the right to maintain contact and even share legal guardianship. In many cases, legal rights to a child are seen as the exclusive domain of biological parents, but the Children's Act of 2005 recognizes that a child's well-being can be supported by a wider circle of individuals. Specifically, John relied on two sections of the Children's Act to argue his case. Number one, Section 23. This section allows a person who has an established relationship with a child to apply for rights to contact and care, even if they are not a biological parent. The second one, Section 24, this section allows someone to apply for joint guardianship of a child, even if they are not biologically related to the child. John argued that his relationship with David entitled him to be involved in the child's life, even though they were not biologically related. He had been a father figure since birth, forming a bond that was beneficial to the child. The court found that the relationship between John and David had been valuable to the child's development, and ending the relationship abruptly could be harmful. Obviously, this was welcome news for John, but beyond that, the court's ruling was significant for several reasons. It clarified that non-biological individuals can seek co-guardianship or contact rights based on the strength of their relationship with the child, without needing to challenge the suitability of their biological parent. This removes the need to argue that the biological parent is unfit or unable to care for their child. This ruling has important implications for family law in South Africa. It opens the door for non-biological caregivers such as step-parents, close family friends, or others who have formed a strong bond with a child to apply for legal rights of contact and guardianship without needing to prove the existing parent is unfit. When an adult with no biological relationship to a child nevertheless plays an important role in the child's life, it may be in the child's best interest to allow that relationship to continue, even if it means expanding the boundaries of a traditional definition of family. This case broadens the legal understanding of who can be considered a parent or guardian. It recognizes that loving relationships between adults and children can be formed outside of traditional biological or legal ties, and these relationships can be important to a child's development and well-being. Critically, by affirming that non-biological carers can apply for legal rights without needing to discredit the biological parent, the court has made it easier for children to benefit from the care and involvement of a wider range of supportive adults. Furthermore, it has removed an obstacle that may have prevented some carers from applying for contact. Proof of parental unsuitability is a brutal requirement, which may be wholly unjust in many cases. This ruling offers reassurance to non-biological caregivers that their place in a child's life is legally recognized and valued for its own sake. Modern families come in all shapes and sizes, and a legal framework that is sensitive to the changing society it serves must reflect that reality. This case provides a clear pathway to securing legal rights for anyone in a non-traditional parenting role who wants to remain in a child's life after the breakdown of a relationship. If you can relate to this situation and would like help to maintain contact with a child in your life, get in touch with me on the number below. The law is on your side.